live from Houston, Texas, every Tuesday from 5 p.m. to 6 p.m. Central Time. We do bring in immigration updates. Today we have my business partner, Stephen Brown, with us to discuss because he's the head of the litigation department in our office. And we're going to discuss today about if the 485 has been pending for a long period of time and the priority date is current. What is the best option? Can you sue the USCIS and get the case adjudicated? Since Stephen is the litigation director, he's going to discuss more on that. We're going to discuss on, can you work on a receipt notice when you file a H1B transfer, or do you need an approval, or what are the pros and cons if you work on a receipt notice? We are going to also discuss on working with multiple employers on H1B. Can you work for two employers on H1B? Can you have two H1Bs? Can you work with two employers on GC EAD? We're going to discuss about that. And also, we are noticing that the advanced parole is taking about 17 months. Hopefully, so recently they have modified where they started giving advanced parole for 5 years. If that's going to continue, most probably the problem is going to arise. But if somebody needs to go urgently, what are the options? Can we go to the court and try to get the advanced parole faster? Since Stephen Brown is the head of the litigation department, we're going to discuss more on the litigation today, among other things. When can we take the case to the court? I mean, I filed 485 and it's been pending only for 6 months and my priority date current. Is that the correct time for me to go to the court?
No, I don't think so. And I want to talk a little bit about 485 litigation as a whole. So it's kind of an interesting area. 485 litigation is a little bit of an interesting area because the government has tried to argue that it is in their discretion, right? They have complete discretion over adjustment of status in the U.S. And in order to have a successful APA delay case, the court has to find that the government it's a discrete agency action that they're required to take. Now, we found that there's regulations, and in fact, in one of our cases on appeal, the government admitted, yeah, we have to make decisions, and we all know that. They have to issue a decision, an approval or denial. But I will say 6 months is a little too early. You know, I'm okay to be a little bit more aggressive with the EB1 cases. I mean, Congress made those first preference, but for a reason, but I'd still want to see those pending closer to a year or longer. For EB2, EB3, you know, I'm looking for a year and a half. And of course, I'm going to be honest with you, everybody's going to have unique factors. Maybe there is a reason we need to be more aggressive with your case. You know, you've got a kid who is looking to go to school and needs LPR status. But year and a half is typically about right. We could be more aggressive with EB1. But year and a half is about right.
So somewhere in 18 months timeline after the 485 has been pending for 18 months. And of course, the final action date is current because otherwise they can't get the green card. That's when the time that you normally typically though, what is the timeline though? If I come to you and then I want to get this, because I know the priority dates keep moving back and forth. What is the timeline that typically when you go to the court? I mean, it's not guaranteed you're going to get the result, but how long typically it will take for the court, the entire process to get it though?
So my team, we're equipped to move quickly to get the case filed and served on the government as soon as we can. Once they're served, the government has 60 days to respond to the lawsuit. During that 60 days, you know, we've kind of seen three things happen. Either they go to adjudicate the I-485, you know, approve it, deny it. We've seen only one denial, and it was a justified denial. But, you know, they approve it. We've seen them, hey, we are going to send an RFE or we're going to schedule them for an interview. And at that point, we'll work with the U.S. attorney on maybe coming up with a timeline after that step is done. But that's positive, right? That's a positive step. The government has the option to fight these cases, and at that 60th day, they can do so. And we're prepared to do that, to fight back on it. I think they'd be in the wrong to try to do so. But I always caution people that's in their prerogative. Now, if they file a motion to dismiss, unfortunately, one thing I can't do is control a judge on making a decision quickly. Federal court judges have their own schedule and get to set it kind of as free as they want to. Now, a couple things on that. One, most judges get it. They understand this is a delay case. We're talking about delayed benefits. They're not going to slow things down. And then number two, it's not going to negatively impact your case. If the government files a motion to dismiss and it's being fought in court, the case is still going to proceed. And in fact, we've seen cases where the government files a motion to dismiss and we're fighting it out, and all of a sudden there's a decision. And I don't know if that's a coincidence or not, but it doesn't stop them from making a decision on your case if they're fighting it in court.
Typically, I know that that in 60 days, the USCIS will settle the case, but how much percentage of the cases that you have filed that in 60 days you got the result, either interview or adjudication of the case, Stephen? Percentage.
So,
now, past results are not guaranteed for the in future it's going to happen the same thing. But what's the percentage that you have?
We're seeing pretty good results on getting them adjudicated now. It's hard to give a percentage because, unfortunately, when we did a lot of these last summer, not this summer, but the 2022 summer, what we saw was they ran out of visas in September and then retrogression, right? And so that I have a number of plaintiffs that aren't adjudicated because of retrogression, and we're fighting that out differently for those individuals. But a lot of them that have been current and have stayed current, it's been successful. We're always ready. Like you said, we can't guarantee they're going to resolve it in the 60th day. Maybe, Rahul, your case is the one they're going to decide we're going to put our foot down and start fighting. But we're seeing good results from this, positive results right now. We are doing these on an individual basis, and I think that's helping. We're able to focus more on an individual family's harm than kind of holistic harm that's being had.
Okay, so let's go and discuss the other issues also. Can people work on the receipt notices of the H1B when a person is transferred from company A to company B and company B files the H1B and get a receipt notice? Can they start working on it?
Yeah, absolutely they can. As long as they are maintaining their H1B status and that transfer is filed before the I-94 expires, once it's delivered to USCIS, they're authorized to work for company B right away. They don't need the one misconception, Rahul, is that I have to have the receipt notice. And that's not true. The I-9 handbook that employers use to determine if you're eligible to work allows for showing that it's been delivered to USCIS to let you work.
Okay. And what if there is a denial of the H1B at a later date? What are the consequences when I move from company A to company B and company B H1B gets denied? I start working on the FedEx tracking number.
I think each situation is going to be different, but typically, I would say if your I-94 is still valid, you could try to file again or go back to company A. I mean, your worst case scenario here, obviously would be departing and doing a consular process. It wouldn't be the end of the world. You're not losing your cap number unless there's a fraud issue. But for the most part, there's solutions to work around that allow you to keep working pretty quickly.
Stephen, a lot of questions come on people who want to work for multiple employers. Of course, we see that some people are not employed right now. A lot of people are getting laid off, but there are some skill sets that are high demand, like especially in the artificial intelligence and data science. There's like a lot of demand for this, and security issues too. There's a lot of demand. If somebody wants to do two jobs, let's say I am working with Microsoft, let's call it company A, as Microsoft, and then I want to work on the side with a consulting company. Can I do that on H1B?
You can. So what company B will have to do is file an H1B for what is called concurrent employment. It's becoming increasingly common, I think, since 2020, when people started working more and more remotely and have the ability to kind of hold down two jobs, right? You don't have to physically go into the office. You can work in the evenings for company B. This is totally fine. So you can file a concurrent H1B, work primarily with company A, maintain your status with company A, and then also work part-time with company B.
As probably already all our audiences know that, then the GC EAD, that means when you file the 485, there is an EAD that you get it In this interim EAD that you get it, you can work for multiple companies. You don't have to file any application. You don't have to do anything. You don't have to file a 485J supplement. You don't have to do anything. You can start working for multiple companies. I have seen some of the doctors and dentists working for 5 or 6 companies using the same EAD. Is it a problem? No, it's not a problem. It's perfectly all right for them to work. In the case of H1B, as Steven has pointed out, we need to file a concurrently filed H1B to work for the company. When it comes to the GC EAD, there is no such requirement at all. You can start working for multiple companies. Absolutely not a problem. Now, coming to the million-dollar question here, this is your area, Steven, more than anybody's area, that nowadays they are approving EAD. And you know that the rule for the EAD is that even when the extension is pending for a certain period of time, they can continue working when the EAD extension is pending. We are speaking of additional status EAD, Stephen. Now, when it comes to the advance parole, though, most of the times or sometimes they're not approving the advance parole along with the EAD. The other problem with advance parole is that when the extension of advance parole is pending, Stephen, they cannot travel. They can only use the existing advance parole, which is not expired, to travel, but they cannot use the advance parole, which is extended, and you have a receipt notice. Can you travel on it? Absolutely not. And the USCIS processing time is taking some time, somewhere anywhere between 12 months to 17 months to get the adjudication of the advance parole. And as you know, Stephen, we cannot file an advance parole more than 6 months before the advance parole expires. So in this situation, what do we have the solution from you?
Yeah, I mean, I always encourage people, try the routes you typically will go, expedite requests and all that. But I'll be honest with you, having done a lot of delay litigation, thousands of plaintiffs, where almost every single one has done an expedite request and contacted their congressman, it's never, I've seen it be successful about once or twice. We have been doing a lot of litigation on the interim benefits, that EAD and AP. And obviously, like Rahul said, the EAD, outside of the initial one, we're not seeing a lot of problems with because of the automatic extension. But the AP, certainly, the advanced parole, certainly. What's interesting about that is in the new fee proposal, USCIS says that it takes less than 20 minutes. I don't remember the number off the top of my head right now. Less than 20 minutes to do an I-131. And I think that's too long, right? Already, but not 18 months. We've done a number of these cases, again, individual bases for families. These are a lot more successful, I think, than potentially the 485, because the avenues for fighting this case are a lot different. 485 delay, the government might try to argue there's what's called jurisdiction. Hey, the court, you can't even look at this. It's our discretion. There is no discretion in the interim benefits and the advanced parole. If you have a pending 485, you are entitled to a decision on an I-131. Now, obviously, if you've traveled, that might abandon it if it's the initial one. But outside of that, you're entitled to an I-131. The agency recognized 485s might take a while. We're going to give you quasi-green card benefits. So we're going to do this. So I think they're great cases. I think those are going a lot quicker. The U.S. attorneys realize it's a little silly to fight something that doesn't take the agency more than 15, 20 minutes. Now, of course, they can change their mind on that. But again, kind of that same 60-day timeline from when the government served. But these are good cases to bring. We're working on something on potentially changing how advanced paroles are dealt with for extensions. That's kind of a little bit ways off. It's going to require a lot of research and effort before we get there. But right now, individual cases for families for delayed I-131s, take it. If your initial I-765 is delayed, we can do that too.
Stephen, there is a perception that litigation is very expensive because you have to go to the court. There's a lot of things involved in it. How expensive is it to go for the delay of the 485, the delay of the I-131 or advance parole?
Yeah, I mean, look, it isn't the cheapest thing, but we do try to keep it price effective. Our big thing is I'm going to be very upfront with you with the costs. I'm going to tell you what the cost is going to be based off of what I think the work is going to take on your case. And then we're not charging extra. We're not, if we've got to fight the case out, we're not charging extra. In fact, a colleague of mine have a couple cases on appeal right now. We're not charging extra for that. We're going to be very upfront about what it is. You're going to know what it is. If you don't want to do it, I understand. If you want to do it, that we're good to go.
Anything else, Stephen, before we go to Q&A?
Yeah, one thing, and I know on the line of cost, a couple years ago we were doing group cases for delays of H4 EADs, and that really helped reduce the cost a lot. Unfortunately, the government tries to take procedural motions on those, just saying, oh, these should all be separated out because they all have unique facts. So unfortunately, that's why we're having to do these as individual kind of cases, is wanting to avoid. I'd rather, if the government's going to fight on the case, I'd rather do it on the merits of the case than this procedural nonsense. You don't want nobody wants to have me explain civil procedure to them. You'd rather hear about the merits of the case.
Okay, so we'll go to the Q&A then. The question that came from Srikar from YouTube is that he has an I-140 approval. He has a soft copy of I-140 approval, and he wants to now move to India. And then he was contemplating, can he come back with a different company on H1B? And is a soft copy of the I-140 good enough for him to come back on a different company's H1B? I'm assuming, Srikar, that your I-140 has been approved for more than 6 months and it's not been withdrawn within that period of time. Then if you have an I-140 approval with company A, and you leave the country and you want to come back after 5 years on H1B, absolutely you can come back. Do you need to come back with the same company A? No. Can you come back in company B? Absolutely. Can you come back in company C? Absolutely. In what period of time that you can come back? You can come back at any point of time. Absolutely not a problem at all.
A question from, I like this name, I learned from RN Law. Is there any way for an automatic visa stamp once extension of H1B is approved, stateside stamping? No, and I think a couple of weeks ago, Rahul, you and Emily talked about this. We were hoping to see it this year. I think they're talking beginning of next year, hopefully to bring in the stateside visa processing. So right now, no, you can't get your visa stamp here in the U.S.
With regards to the expediting of the I-131, I-765, Vinod Kumar and Reddy, just go through the initial part of our video. Stephen has covered those items in there, though.
Manoj asked a question from YouTube. Filed H1, H4, H4 EAD together. All of them are approved. H4 EAD is already expired. Is waiting for the approval notice the only option? Yes. Unfortunately, the answer is yes. So I'm actually dealing with this with a client right now. The H4 EAD, the card itself, is the only valid I-9 document for them to do re-verification. So even though it's been approved and you're authorized to work, and we all know you're authorized to work, the company can't properly do I-9.
But Stephen, if it's an extension of the EAD, though, isn't he authorized to work even though he hasn't received the approval yet? And he has the H4 approval.
So for the H4 EAD, without the card, the company wouldn't be able to do I-9 re-verification until they get the card. He's authorized to work. The company just can't properly I-9 him, in my opinion.
No, I just want to go through the exception that's there, Stephen, that if the H4 extension is already approved.
Yeah.
Then.
But they doesn't have the H4 approval yet either.
Okay. I thought H4 approval is there. Okay, I got it.
No, they were just approved yesterday. So yeah, if you have the H4 approval, you could say, hey, I'm now in this automatic extension period. My EAD is still pending technically because I don't have the card. But you would still need the H4 approval to show the company.
We're on the same page.
Yeah.
We're on the same page. There are a lot of questions with regards to the priority date, guys. It's very hard to predict the priority date. At the most, we're expecting the filing dates to be the final action dates by the end of the year, particularly for Indian nationals. That's what is expected. Then things go up and down as the things move. But it's very hard for immigration lawyers to predict at this point of time how the priority dates will move. So please, I know that majority of the questions will come in there. Please try to avoid those questions because we can't predict any better than what you can.
Uh,
Go ahead.
Sindel asks, how long should I wait after I-140 is approved to file the I-485? Reach out to me. I mean, I think that's going to be a very fact-dependent. I've taken some where, we talk about the 2020 cases, right? Everybody filed together. I need your I-140 approved, but I filed some like very quickly after the I-140 is approved. They should have been working on your 485 during that time. So reach out to me. I'm happy to take a look at it.
Question from Jan that you said previously that in the consulate they have rejected they have some rejection of the they have the rejection of the advanced parole. They have the rejection of the cases who filed multiple applications. When they went to the consulate, they got the visa directly rejected though. He's asking how can they reject it without NOID, notice of intent to deny, notice of intent to revoke. First of all, notice of intent to deny, notice of intent to revoke is only for the USCIS, not for the consulate though. The consulate don't have that. What we have seen in the consulates is that they're issuing a misrepresentation. They're telling that if this individual has cooperated with the employer in filing the multiple applications, he is part of misrepresenting in obtaining the immigration benefits. Thus, it's a lifetime ban for them to ever come back into the United States. We see it very frequently. We get a lot of consultations from the people who go for the consulate. That's where they get stuck in there. And initially, though, we were unable to figure out what happened because sometimes the consulate don't give any reason. They just say misrepresentation and they ask you why. And they just say contact your lawyer. And then when they contact us, we don't know why it's misrepresentation. But when we go through every item, what they have ever done in their life, that's the only conclusion that we came up is the multiple filings. So. And it's not happened with one, it happened with lots of people. So that's the way it's easy for us to conclude why multiple filings may have a hard time in getting the H1B approved or stamping in India.
Two questions here. Any way to expedite I-131 and any way to expedite I-765? Take a look at the beginning of the video here. We talked about litigation options for both of those. Feel free to reach out to me on that.
A question with regards to the people who are moved from H1 to H4. And after the I-140 is approved, can they move back to the H1B using the I-140 approval? The answer is yes. Once the I-140 is approved, you can. At the time when your I-140 is approved, you don't have to be on H1B. You can be on H4. A lot of people are a bit confused on it, that once they move to the H4 EAD or H4, can they still file the labor certification and get back to H1B at a later date? Absolutely, you can. You don't have to be on H1B when you file the labor certification. You don't have to be on H1B when you file the I-140 application. You can resurrect. We have seen people who have moved from H1 to H4 or F1 and then come back to the H1B later on after the I-140 is approved. That is possible.
Question here from YouTube, FOIA question. If I file an I-485 FOIA request to get records from USCIS, would it cause any delays to ending pending 485, I-131, 765? No. It's a separate process. There shouldn't be any reason it would delay anything related to an adjudication other than USCIS is probably the worst agency for timely responding to FOIA requests.
Kelvin has this question. If I get my employer sign the I-140, I-485, can I choose a third-party lawyer to file the 485 application? The answer is yes, as long as your employer is okay with it, that to file through a third party, then you're fine. I mean, some of the employers will say, no, we won't allow it. So it's better to stick with the employer lawyer if the employer says to stick with the employer lawyer. But if you get the 485J supplement, though, can you go to a third-party lawyer? Yes. We have a lot of multinational companies, especially the big 5 companies. 2 of those companies we represent, where they give us, the companies gives us a 485J supplement, and then we just use that to file the I-485 application, to file the 485, and no problem with it. Especially, you're asking the question about the I-140, though. Now, I-485 is different than I-140. If we get the I-485J supplement signed, we can file the I-485, not a problem though. When it comes to the I-140 though, can the employer sign and use the third-party lawyer? Yes, technically that's possible, but let me tell you practically though, it's very unlikely the employer will allow the I-140. I've seen a lot of employers allowing the 485 application to be filed by third-party lawyers, but not I-140, because I-140 involves, if it's a small company, it involves a lot of financial documents, income tax returns, which they don't want to share with a third-party lawyer though. You just want your I-140 and 485 approval. So do whatever it is to take, and you don't have to go to a third-party lawyer. Just go through the initial lawyer, get the I-140 485 file, and once the I-140 is approved, you can always move later on to your own choosing of your lawyer.
There's a question here about some of the judges frowning upon some litigation being filed. So there's a number of cases I've been working on with a colleague of mine from another firm, challenging what we're calling the retrogression hold policies from USCIS and Department of State. Basically, our interpretation of the INA, and if you look back at some of the old congressional notes, kind of leads to a finding that Congress tried to create a system of once current, only current. What does that mean? If your final action date became current, even if the visa bulletin retrogressed, you only need to have green cards available, not current. They took out the original language was you have to have current and available. They took out current and just said available. Now we know on October 1st of this year, 144,000 plus green cards became available. So why is this case a little tough? It is a complete challenge to the immigration system. This was a case that, we talked with our plaintiffs on. We expected to be dealt with at the appellate level. That if we were successful, the government was going to appeal. If the government was successful, we were going to appeal. It's a case that really, and Rahul will understand, is more of an appellate level case than a district court case. It's a lot more nuanced than most district court judges. But outside of that, we're seeing outside of DC, right? DC judges aren't liking anything immigration. Most judges are getting the immigration problem. That's not to say we're going to win every case. But I'm not seeing a lot of pushback from judges outside of this very niche issue with retrogression that we knew we were going to be appealing.
MB from YouTube has this question. She has the EB3 Mexico. She's from Mexico pending. If her husband gets the I-140 approval and EB1, can she file as a dependent though? The main question that comes is that, are you maintaining the non-immigrant status, either TN visa or H1B? If you're maintaining the non-immigrant status, you don't have any problem whatsoever at all in adding yourself into your husband's 485 application when the I-140 for EB1 for your husband is approved. JS asked this question from YouTube. Are we expecting a third round of lottery, given the number of notice of intent to deny, notice of intent to revoke, multiple filings? Yes, JS, you're right. There's a good possibility that we're expecting a third round of lottery this year. Not just the notice of intent to deny, not just the notice of intent to revoke though, but we're also noticing a lot of companies not filing the H1Bs at all, even though they're selected in the lottery though, because they see a lot of prosecution going on, they see a lot of revocation going on, they see a lot of intent to deny going on. They just choose not to file the applications at all. In fact, we have noticed some of the consultations that we get from the people, some of the companies have filed thousands of H1Bs. One particular company, a group of company in Dallas, have filed 2,000 H1Bs. Out of this, 400 got selected. Seems that they have only applied 3 or 4 of those 400 plus applications. They have only filed 4 or 5 applications. That shows the magnitude of amount of cases that they didn't file the H1Bs. Now, these are the consultations, believe us, we didn't file for them at all. These are the consultations we get when they hear these things. When we get the consultation, we can see the notice of intent to deny or a notice of intent to revoke these applications. And in those applications, they point out, look, there are 5 companies and there are common directors for these companies. And the same employees were being filed by 5 of these companies so many times. They mention it very clearly, and these people have nothing to defend at that point of time. and they will just withdraw those notices of intent to revoke. So these are the kind of cases where we see that people are not filing. Yes, JS, there is a good possibility that we may get the third lottery. The only issue is that since the deadline is not over to file the second lottery, though, we have to wait for the deadline to get over and then wait for some more time to see if we are going to get the third lottery.
It's interesting, Rahul, you mentioned that with the companies not filing and then the number. I mean, we're not seeing, okay, I got a job from Amazon and I got a job from Google and I got a job from Meta. It's, and then, hey, that was me. We're seeing a lot of collusion. I keep calling it's dumb criminals, right? They are, the same guy, the same office, the same signatory, the same email address.
The same lawyer sometimes.
Yeah, and we're not saying that they're not gonna get into more details. They might, but it's not like you had multiple real legitimate job offers. It's the people that they're really cracking down on. It's very clear there was an abuse of the system.
Yeah, and that's good they're doing it.
Agree. I saw a question here. My spouse is from Nitin on YouTube. My spouse is on her H1B, but for renewing her driver's license, she used her EAD card from his EB1 green card application. Will this cause any issues with her employment on H1B? No, I don't think you're going to face any issues at all. Two different systems. You just showed the government, your local state government, what they needed to see for a driver's license. I don't think you're going to have any problem at all with H1B.
Neha Tripathi has an I-140 approval. My daughter is 18 years, L2. Is there any way to expedite the 485? Neha, one thing is not sure whether your priority date, final action date is current or not. If the final action date is not current, no, we cannot expedite. I mean, we cannot go to the law. We cannot go to the court though. If the final action date is current for you and your daughter is about to go to college, that may be a good reason for you to litigate. Though the reason is that in some of the colleges there is nothing called adjustment of status. They are going to ask you one question: Are you you have a green card? Are you a non-immigrant visa? And they don't understand the adjustment of status. So it could be a good reason to litigate if the final action date is current. But if the final action date is not current, no, we can't go to the court.
Priya asks on YouTube, any update on PERM processing? Mine was filed in November 2022 and still waiting. So couple months ago, it was October 2020, and now Department of Labor is saying they're working on September 2020. I don't know how they go backwards in time, Rahul, but I guess that's the federal government for you. We're testing a litigation strategy on that. We're not ready to scale it yet. We want to see how the first case goes. But hopefully, Priya, yours is going to get adjudicated here in the next month or so.
Question with regards to the Changi Leo. If we are filed the 485 application based on the Chat B, which is filing dates, does the USCIS adjudication of look at those cases? Do they review it, or they don't touch it until the priority date is current? First of all, they do review it. They do give the EADs. They do give advance paroles. We see a multiple of cases. People get interviews even if the filing date is not current. It's very common that the reason why they want to do it is, what if you file, you're completely not eligible for 485, even though you have an I-140 approval, you may not be completely eligible, and they don't want to keep on giving you EAD in advance parole and make you stay in this country. So they do adjudicate the cases, they do check on the cases, they do interview the people, even if the priority date is not current. Even if the filing date is current, later on, if the filing date is not current, also they do interview people.
PM asks this question: why did USCIS approve 2014 priority date green cards when 2022, 12, and 2013 we're still waiting on it?
Question.
It's a good question. I think they violated the law. We also, part of that, they left out spouses, derivative spouses, and children. And we're looking at filing a case for spouses and children that were left behind without adjudications in the next, probably beginning of November. But I agree, PM. I think they violated the law on that. Unfortunately, that's going to be hard to challenge.
Would the green card become invalid once the ongoing extension is approved? So Sahul Ahmed most probably got the green card, and later on they extended the H1B. Does the there's something called the last action rule? No, Sahul, that's not applicable to you. You got the green card. What you do with the H1B approval that you got it after you get the green card is you take it, you tear it, put in the trash can, or you can do one thing: you can eat peanuts in it. That's a good thing you can do it.
Durrati asked the question, does the shutdown affect USCIS? The answer is no to your question, but some of the things that may be needed to get to USCIS are. So if there is a government shutdown next month, Department of Labor would shut down. So filing LCAs, filing PERM, getting LCAs or the PERMs adjudicated would not happen. But filing with USCIS and adjudication with USCIS, no, it's a fee-funded agency.
But Stephen, it's like you telling me that, oh, well, we can live without oxygen kind of thing, because LCA is an absolute necessary though.
Right. So,
for H1Bs, yeah, it's LCA is an oxygen. Without that, we can't file it. So to say that practically, yeah. What I would tell people about panicking on this shutdown is that, I've been in practice for a long period of time, maybe before Stephen was born, something like that. This threat of shutdown happens every 3-4 years. A lot of times, I've only seen shutdown maybe one time in the Clinton time. That's what I've seen. Not much after that. That was like a long time ago. Clinton was 1992, guys. Most of you guys were not even born. Or born, I don't know. So yeah, it's a long time. We haven't seen any significant shutoffs after that. At the most, we have seen 3-4 days, 4-5 days. That's all we have seen. Don't be panicked with that. They somehow in the middle of a night, you keep on watching the news, somehow they will settle the matter and then keep on extending it. That's been going on like for past 30 years. But yeah, going to the point, as Stephen has pointed out, other than the Department of Labor, which requires, for example, for H1Bs, we definitely will have a problem because LCA won't be approved. If the LCA is not there, we can't file the H1B.
Question here from Vinod. If an H1B gets promoted with a salary increase as part of career progression, is H1B amendment needed? I would say most likely not, Vinod. An amendment's needed, if you move outside of the area of intended employment or if there is a material change to the employment. Now, that's not really well defined by Department of Labor, who governs the LCA. But typically, a promotion in line with a salary increase is not going to require an amendment. Now, if you go from being a software developer to an attorney or, the CEO, probably going to need an amendment. But if you're getting a normal increase, raise, bonus, no.
Questions that we get very normally is that I have an H4 EAD and I have a GC EAD. My H4 EAD expired. I am now working on GC EAD. Now I got an H4 EAD. What is my status? I don't know. Who is asking this question to you? It's like this. You're traveling from LA to New York. You have 2 tickets. One ticket is H4 EAD. One ticket is let's say it's a wrong example going in the flight. I would say, you are going in a train. Okay, you're going in a train from New York to Washington, D.C. And you have 2 tickets. One ticket is GC EAD, one ticket is H4 EAD. The question is, if nobody is asking you the question, well, you can say whatever you are in, depending on what you want. If nobody's asking, you're fine with both. If somebody asks you at that point of time, then you can provide one particular thing, though. So these kind of questions, which status I am in, is very confusing for us. You are in both statuses. You can use both statuses. For working, you can switch from one to another at any point of time with no problem.
Question we just got here: could someone work while they're in that period of authorized stay while workers study in that period of authorized stay while the I-485 is pending and non-immigrant visa is expiring? Person has the EAD and AP. Yes, you can. You can work and study. I would go back to Rahul's point from earlier. there are some colleges who don't understand what this means. And so you might have to explain it to them. But outside of that, there's no issues. And the EAD, the green card EAD, is an unrestricted right to work. You can go work at the local CVS. You could go work at NASA. As long as you're doing legal work that doesn't violate the laws, you're okay.
Changilio, he has 485 and AP pending. Can he go to Mexico or Canada to get the H1B stamping? Are there any risks associated? He already knows that H1B is a dual intent. You're right, Mr. Changilio. H1B is a dual intent. Just because you file the 485, you don't have any extra risk, though. Absolutely no extra risk. It's just a normal risk when anybody has it. They're not going to deny your H1B because you filed a 485 application.
If it's your initial advanced parole and you go to Canada or Mexico, your advanced parole might be denied.
Thank you.
But that's okay. Just refile. But if you are in H1B status and you leave and you come back in H1B status, it's not going to negatively impact your I-485. You just have to refile that AP.
Moved from employer A to employer B in January 2023. USCIS approved the 485J transfer of underlying basis and not approve my 485J based on AC21. With my new employer B, are they crazy? No, sometimes they do approve the 485J supplement, sometimes they don't. And we have seen a lot of cases where they have never approved the 485J supplement and they directly approve the 485. That is possible. I mean, it's not an absolute necessary that the 485J has to be approved before you get the green card. It's an absolute necessary for the I-140 to be approved for you to get the 485 adjudicated, but it's not needed to approve the 485J supplement to approve your green card application. Especially in 2022, we have seen a lot of cases where no 485J has been approved and they got the green cards.
Trade Education on YouTube asked, does USCIS know if we quit versus being let go on H1B? If they do they consider performance-based terminations as grounds for future H1B? So unless your employer notifies them the reason for termination, the answer is no. Or they're not going to know if you quit or let go. I don't think I've ever seen performance. Performance isn't going to be an aspect of the H1B. It's, is it a specialty occupation and do you qualify for it? Not are you good at your job? That's not going to be a factor in it.
Praveen Pohar has this question. Applied immediate relative for mom, applied 485, I-131 advanced parole. It's been pending for 16 months and it's no update, out of normal processing, service request. What can we do? Now, this is a case where you can go to the lawsuit. That's one thing, but it's 16 months. I'm not sure if that's the right time for you to go to the court, though. Probably
definitely for the I-131. Huh? Definitely the I-130, the I-131, the advanced parole.
My only thing, Stephen, is that since it's 16 months, they may actually get naturally approved.
True.
That's the reason where I'm thinking of maybe they should wait, because either way, if they come to you, it's going to take, after you file the case, it takes 60 days for you. So approximately around, to filing, serving, and all those things is 70 days. Is it worth for them to spend the money?
And Praveen, I'm doubtful. Yeah, what you may want to consider, and I've done an immediate relative case where we were doing on the interim benefits and then threw in the 485 as an additional claim, and it worked out. So another way to think about it.
So you went for both adjudication of I-131 and the 485.
Yeah, I've done some like that, especially more recently with them being so bad about the I-131s.
Yeah, I got the point. That's a good point. Probably, it's worth for him because he would get both of those things adjudicated. Very good chance for it. Yeah, it's probably worth for him.
And immediate relatives are interesting because there's no cap. You're not subject to the visa bulletin. If you're a true immediate relative, you're always current.
Always current, of course. Kumar, after 8 years in US, his I-140 has been approved in 2018. Decided to move back to UK. Do you see any light in getting in the next 10 to 15 years? That's anybody's guess right now. That's anybody's guess right now. Please don't ask me the question about how the priority dates are going to move, but there is something that I can tell that I'm the best in the world, or the worst in the world, I would say, not the best. In predicting the priority dates, I can tell that I predicted the priority date worse than anybody else in the entire world. And so many times I predicted badly in the priority date. I can prove with evidence that I'm the worst. You bring anybody, I have so much evidence I can prove I'm the worst.
Yeah, the visa bulletin is such a hard thing to guess. If any attorney is telling you that they know exactly what the visa bulletin is going to do, the only way I would think that's going to happen is if they have FOIA'd a lot of data and gone through the analysis that they've specifically done.
Question with regards to people who are losing the jobs. What is the best option for them at this point of time? There's always two things. If you have an I-140 approval, though, there is a compelling circumstances EAD that you can consider it. Previously, we were recommending a lot of compelling circumstances EAD. But lately, though, from about February and March of 2023, we're kind of discouraging compelling circumstances EAD, encouraging people to file the B2 application, though. The reason is that USCIS in its tweet has said that if you file a B2 application, if your B2 is pending and you want to move back to H1B, even though the B2 is pending, they are going to adjudicate your H1B application so that you don't have to leave the country to get back into H1B. And after the tweet, they actually did implemented those things, though. So we started discouraging people. Now with people who are on losing their jobs, we're encouraging more to move on to B2 if they don't want to leave the country, and they can always come back to H1B if they have any leftover period under 6 years, or if their I-140 is approved, they can always come back to H1B without going through the lottery system and without going outside the country. You can change from B2 to H1B. So many times our office has filed from B2 pending to H1B. We got successful in it. Now, this only started coming in February and March of 2023. Previous to that, though, it was hit and miss. Sometimes they used to change the status from B2 pending to the H1B. Sometimes they used to say go to the consular processing. But we haven't seen any consular processing recently. So we strongly advise people, if you want to stick around for a while to look for the jobs, you probably may want to do that.
A question from Krishna here. Do LCAs need to be submitted to the Department of Labor and posted for 7 days for an H-1B amendment? So I think you've got some dates here mixed up. So the Department of Labor typically takes 7 days to certify an LCA. The posting requirement is 10 days. You have to have the LCA posted for 10 days.
Manoj Kumar has this question. Can a H4 EAD file an unemployment benefit? Will it cause any problem to the green card? Absolutely. You can file the unemployment benefits. Absolutely not a problem. Will not cause. Now, this is only for the H4 EAD, not for H1B, guys. Only for H4 EAD. And people also ask me a question. On the green card, though, can I apply for the unemployment benefits? Absolutely, you can. No problem with it. Will not cause any problem whatsoever at all for your green card or for your citizenship. Can I file F1 change of status if I lose the job, even though I completed my master's degree? Can I move into a different master's degree and file the F1 change of status? Absolutely, yes, you can. However, you're not going to get one more OPT, though. If you have received an OPT and used the OPT in the master's degree, now you're doing another master's degree, you cannot get one more OPT. It's done. You cannot get one more OPT.
Suresh asked about the possible third lottery. We talked about that a little bit earlier. Rahul and I both think, I mean, look, I could be wrong just as bad as Rahul is at the green card visa bulletin. I am about guessing lotteries, but I think there's going to be a third one. I think the data shows there will be.
I'm an H1B and my employer applied for extension premium process. I got the approval email from employer. I see that there is an I-94 number in the email along with the port of entry notified. As long as you have the I-94 number, even though port has been notified, you're fine. When you get the I-797 approval, check it very, very carefully if it's I-797A and does it have an I-94 at the bottom. Most probably, if you have an I-94 number in the email though, you should get an H1B approval with the I-94.
Yeah, Pavan, they started doing that last year or two. We fill out which consulate would be notified just to kind of avoid a problem. And so they've started now putting it on there. I wouldn't read too much into it unless you got an RFE about your status.
K. Vinod has this question. He entered into 2012. I never exited. The departure record shows 2013 October. Want to correct the departure record. Can I go to Canada, visitor visa, and fly or drive back to correct the I-94? You don't have to worry about it, Vinod. Because if you really exited according to their records, you should not getting the H1B extensions or whatever visa extensions. You're here from 2012 to here. Most probably either you're F1 or H1. You probably extended or transferred your visa status. And you're going through smoothly. You absolutely don't have to do anything. Don't worry about it. As long as you have the approval of the I-797A, most probably an H1B, you have the I-94 attached to it, you can ignore the online. We have seen the mistakes of the CBP so many times, you can ignore that.
And Vinod, to Raul's point, I think the worst case you would get is when you do an H1B, they would say, hey, the records show you departed and never re-entered. Prove that this individual is here for purposes of the I-94. I had that earlier this year where an individual took a cruise and they never showed that they returned, but we had all the paperwork showing that they've been paying bills, they have a mortgage, they have been using the credit card, all that stuff, and it was approved without an issue. So outside of that hiccup, I think that's the only time you would see that. But like Raul said, it's common. CBP actually has a thing saying this isn't for legal purposes because there's so many mistakes.
Raj has this question. How do I confirm whether I'm an EB3 after downgrading? You can't. You can't confirm. The only way you confirm is when they give the green card, an EB3, you will find it on the green card approval whether you are an EB3 or EB2. In general, though, they can adjudicate your application in either EB2 or EB3, especially in 2021 and 2022. We have seen the USCIS doing approvals even though we didn't request it on EB2. When the EB2 became current, they just pulled out the EB2 and approved the green cards. Well, we didn't object to it, we just took it. So just because you downgraded doesn't mean that you are stuck in EB3. You can actually flip around yourself depending on whether or not EB2 or EB3 is current. So if your EB2 is current, you're not going to say, oh, I filed an EB3, I'm going to stick with it no long, even if it takes 20 years, I'm going to stick it. No, you're not going to do that. If EB2 moves forward, hey, approve my case in EB2. If EB3 moves forward, you just request the USCIS in EB3. So you are in both statuses at this point of time. Whichever comes forward, you will tell the USCIS to adjudicate on that basis.
Question here. I have a H1B. My workplace is Atlanta. I'm in India. I want to drop a relative at Philadelphia and then go to Atlanta. Will there be any port of entry issues since I'm entering in a different city? I don't think so. As long as you're explaining to the CBP officer, hey, my relative's with me. They're going to Philadelphia. I'm just going to make sure they're okay. I'm not working here in Philadelphia. Here's my ticket to Atlanta. I don't think you're going to have any problem.
Krishna has this question. How do I know that whether I-140 has been withdrawn within 6 months after it's been approved? Easy way. There is something called Freedom of Information. It's called FOIA, USCIS. You can Google it and you can fill that application within 10 minutes. You can fill this out. You can request the A file. They're going to give you the I-140 application form that the employer files. On that I-140 application form, it tells whether that I-140, when it was approved, what is the file number, and if it's been withdrawn. If it's been withdrawn, on what day it's been withdrawn. They will have a notes on the I-140 in the first page of the I-140. Based on that, you can determine whether or not your I-140 has been withdrawn within 6 months or not. And it's easy, it's free, it's online, it takes only 10 minutes. Once you file it, it takes 6 weeks for you to get it. And your employer won't know that you filed it or you obtained this one.
Raj, as I'm current in EB3 after downgrading in October, will filing I-693 help move the file? Rahul, what are your thoughts on just preemptively filing a 693? I mean, I think it goes into a black hole. Personally, I would keep a second one. I don't think they're going to do anything with that.
Yeah, I would not do that right now. I would not do that right now. Krishna has this question. Not Krishna. It's an interesting question that came out. I forgot. Maybe the person deleted the question. I got my EB3 I-140 approved. Now I changed my citizenship to Canada. Is there any advantage? No, actually. Unfortunately not, though. The reason is that the priority date is based on the country of birth. The immigrant visas are always at the time of your birth, though. So if you later on acquire a different citizenship, can you move the priority date to that country? No, unfortunately not. So if you're born in India and later on you acquire the Canadian citizenship, you won't come under the Canadian quota at all. Absolutely you won't. Unfortunately, you won't. You would still come under. For the non-immigrant visas, though, which is H1Bs, TNs, E visas, you will be considered to be a Canadian citizen, though. So you can claim the TN visas, you can claim the E2 visas, but when it comes to the green card, though, it is based on the country of birth where you are at.
I think this is a good question here from YouTube. References on the internet say period of authorized stay is not a legal status, and one must maintain some non-immigrant status while 485 is pending to remain lawful. So a period of authorized stay and status are two different things. And when you have a pending 485 and no non-immigrant status, you don't have a status, but you're in the period of authorized stay. It is a very nuanced legalese thing. But when you have a pending 485, you are lawfully eligible to stay in the United States as long as that 485 is pending. Once your C9 EAD is approved, you are now lawfully able to work pursuant to that EAD. Even though you're not in a quote unquote status, you can still work. It's a very nuanced distinction. But for purposes of 485, you can almost treat a pending 485 like its status, other than the fact that you couldn't file another 485.
Yeah, I personally myself let my non-immigrant status go and then started using the EAD. I was an immigration lawyer. I even attended a couple of interviews for not mine, but some of my clients as a lawyer on the 485 EAD. Not a problem, guys. I'm currently an L2 visa. Will soon be out of status because I will be turning 21 years old. But I got my EAD recently. Now, the main question would be that, are you covered under the Child Service Protection Act, though? If you're covered under the Child Service Protection Act, which requires that the I-140 must be approved, the filing dates must be current, you must be under 21, the 485 must have been filed. If all of them meet the requirement, we call it as you're protected by the Child Service Protection Act. Now, all these things need to happen in one time. They cannot scatter around. You cannot have an I-140 approval in one date and filing dates to be current at a different date. That doesn't work. If you're protected by the Child Service Protection Act, though, you don't need to technically move into F1 visa. You can stay on the EAD. Now, it's up to you. You can move on to the F1 if you want to. Because you move on to the F1 visa doesn't mean that you're out of 485 application, but you're still in 485 and maintaining the F1. But personally, if I were you, if I'm protected by this Child Service Protection Act, I am not going to move on to F1 visa. Anything else, Stephen?
No. Any of you guys know we talked a lot about litigation. Reach out to our office, and I'm happy to talk with you kind of about pros and cons of it and whether it'd be a good choice for you.
And if you want to make an appointment with any of me, Stephen, or any of our colleagues, guys, the link is provided there. Our schedule is available online. You can block the time that's more suitable to you to discuss. Sometimes people can have group people, like 3 or 4 people, book one appointment. to save some, finances for them, that's possible. You can, it's your time. Some people ask for the Zoom calls and they have a couple of people there, that you can do that too. The links are provided there for you. Anything else, Steven?
No, thanks. Thanks everybody for attending.
Thank you very much for tuning in, guys.